For organizations mounting opposition to the mine, Dr. Sainsbury's report represented another troubling issue: the lack of transparency and outright impropriety of the DEQ's handling of the issue.
At first, we were told by the director of the DEQ that the memo didn't exist. And then we pushed harder and harder. And finally, it came out that the memo actually did exist and that a DEQ employee had intentionally not included it in the public record, and in fact had told Dr. Sainsbury to change the memo, to take out any references of case histories from other mines, which every rock mechanics expert will tell you is critical.
Only 2 months earlier, the agency had issued a preliminary decision to grant the mine. Now, in light of the Sainsbury review, the department had lost the confidence of the public and ultimately chose to withdraw the proposed approval.
The DEQ instituted a process for setting up an investigation of the situation. However, the investigator was a former employee.
The investigation, conducted by consultant Donald Inman, tragically missed the mark. Only those who worked for the DEQ were interviewed, fueling community concerns about the lack of impartiality. The investigator reported that the DEQ's Mackey, when speaking of the mine, said this was my baby, and talked about how he often made decisions because he did not want to bother his superiors with details. Mackey, who by his own admission had never been involved in permitting a sulfide mine and has taken less than 2 weeks of classwork on the topic, is an integral part of the state's mining review team.
The conflicting scientific testimony, I think, has to be resolved by government agencies who don't have a particular bias to one side or another, who are being paid by the taxpayers and are responsible to the taxpayers and to the citizens of the state of Michigan.
DEQ bias in favor of Kennecott is exactly what community members fear, especially after they see emails sent from Mackey's supervisor, Steve Wilson, with the tagline, "A mine is a terrible thing to waste."
I heard an individual in the DEQ, Mr. Joe Mackey, who was the individual who reviewed, had the mining team to review this application, indicate that Kennecott was their customer.
When you have incidents like the Sainsbury report, where a report is so important to the project, to the safety of the project, and I'm not just talking about environmental safety, we're talking about whether the roof is going to collapse on workers. When nobody's taking that seriously, boy, that says something about our Department of Environmental Quality and how ill-equipped they are to consider the technical aspects of this project.
Further evidence of the DEQ's failure to implement Michigan law came to light in court testimony. One critical standard set forth in state statute requires the company to prove it will not pollute, impair, or destroy natural resources. Under oath, the DEQ's Mackey responded to questions about whether he had applied this critical standard when reviewing the application. Attorney: did you apply this section of the statute to your analysis? Mackey: I did not. No. Attorney: did the mining team apply this section of the statute to its analysis? Mackey: I don't believe so. No.
If you ask people in Lansing, in the legislature, in the bureaucracy, in the lobbying community, they will tell you to a person, the DEQ is underfunded, the DEQ is understaffed, the DEQ lacks the capacity to carry out the complex, technical, hard-knuckle requirements in order to enforce this statute.
I can't say I'm fully confident, but I think they're doing the absolute best they can with what they have, and hopefully, as the economic situation in Michigan improves, they'll be staffed and funded to an adequate level.
Why, many have asked, is this project moving forward when so many agree that the DEQ is ill-prepared to regulate and monitor sulfide mining?
I believe that the mining companies have convinced the state of Michigan that if they don't allow this mining to occur, they will bring a takings claim and demand that the state pay them essentially for the value of those minerals. And the state, of course, is gun-shy about that possibility, especially when you take into account that the value of those minerals currently is valued somewhere in the neighborhood of between $5 and $10 or so billion just for that one deposit.
Senator Prusi said that both Kennecott and the DEQ have mentioned the possibility of a takings lawsuit against the state.
There have been talk that because Kennecott owns the mineral rights for a substantial portion of the land, is leasing other mineral rights. If they are denied the opportunity, they will in turn sue the state for the value of that ore body that they're being denied the opportunity to gain the economic advantage of.
Opponents quickly point to the mineral rights lease signed by the state that specifies that the lease is not authorization to explore or mine. Still, Senator Prusi seems unconvinced.
Given the current economic climate and the budget that the state of Michigan is working with, I don't know where we'd come up with the money to pay Kennecott not to mine.